Hi, this is Danny, the IE legal guy. So, a couple of questions have come my way, and I appreciate every single question that anyone sends. Please feel free to leave a comment or post on the Facebook page, or you could send it to me anonymously, ielegalguy@gmail.com. So, one of the questions asked was, what do you do when the other side has an attorney and you don't? Well, the easy answer would be get an attorney. And I understand that a lot of people don't necessarily have the resources available to them to get an attorney. Just keep in mind that the attorneys have to follow certain rules like anyone else. And, the court will hear both sides of the story. One of the big tips would be don't be intimidated. Try to be realistic, try to be practical. You're not going to beat an attorney in arguing legalities. You might have that ability, but you only have about 15 minutes per hearing on average. So you're going to have to pick and choose your battles. Like I said, go in with a practical plan. If something is being alleged that is not necessarily true, kind of think a second and figure out whether or not it's something worth fighting, or maybe ask the court to give you some time so you can get an attorney. And you're going to have to figure out a way to get an attorney or do the research or whatever is necessary to make things happen. Going to court when the other side has an attorney most definitely has its hurdles you're going to have to go over, and there are complications. You're dealing with another person who presumably has more education, experience, background of the legal system. But the awareness part is where you can catch up and put yourself in a position where you can match with the attorney. Be aware of the rules, be aware of the procedures. And generally speaking, being practical can help you in getting the orders or provide you a defense to the allegations that are being presented against you. Since I primarily focus on family law, one of the tips I provide to other people is simply focus on the logistics. I don't care if you have an attorney on the other side. If you demonstrate through the awareness of the children's pickup, drop-off times, and the logistics of how you are able to and the other parent is unable to take care of the pickups, drop-offs, and taking care of the other needs of the children or child, then that generally can put you in a good position. You can argue whatever law you want, but if you are available and the other parent isn't, that generally would demonstrate that you are not only aware of your child's circumstances, situation, and items that need to get done, but you also have an ability to do so. Like anything else, your mileage may vary on whether or not the court will view it in this way. But at the end of the day, if you're available and the other parent isn't, and if the solution is to have a third party representative act as the parent, who do you think the court's going to pick? A parent who's available or a third party representative? That's just something that I've had much success in with my clients, with other people I've spoken with, and even for myself. Because yes, I am also a person who's been involved with the legal system. I've been there, done that. I've sat in the courtroom. I understand what it's like. And remember, I have attorney friends and I have attorney colleagues who can go to court with me. So I understand going against an attorney can most definitely be an intimidating thing. But remember, be practical, be aware of the situation, be aware of the circumstances, and if all else fails, feel free to ask the court to give you some time to get an attorney. Nothing wrong with saying, I can't do this. I need help, and you need the time to get this help. Until next time, this is Danny Martinez, the IE Legal Guy. Be well, stay safe, and good luck on your court case.